The court has received a motion for mistrial for the sentencing phase and an objection to the motion for mistrial sentencing phase. Mr. Nurmi, you wanted these motions heard in open court. Do you have additional argument?
I do, Your Honor. Once this trial started, the prosecutor, in violation of State v. Smith, disrespected defense counsel in front of the jury.
Would you like it if I stood over here, like your counsel was asking you the questions? Would that make you feel more comfortable?
Yes, Your Honor, improper comment on counsel.
Sustained, rephrase.
Would it make you feel more comfortable if I stood over here and used the lectern, ma'am?
Why don't we approach again before he does the same thing over and over again, Judge?
Mr. Nurmi, are you asking to approach the bench with an objection? You may approach.
In violation of in re Zawada, the state attacked expert witnesses in front of the jury.
Do you have any problems with your memory? Because this just happened.
No, I do not have problems with my memory, sir.
Do you have a problem with remembering what I just asked?
No, I don't have any more problem than you do, sir.
Because you have feelings for the defendant, right?
I beg your pardon, sir.
Jose.
In between all these things that were going on, all in violation of Ms. Arias' rights, we have the issue of witness intimidation. This cannot be a modern-day version of days gone by of stoning or of witch trials. Now we're in a situation, Judge, where a key mitigation witness, someone who knew Ms. Arias long before Mr. Alexander came along and came into her life, has been intimidated, and you can see from the letter, who feels that her life is being threatened to a point where she cannot come forward and testify on Ms. Arias' behalf. This is constitutionally unacceptable under Lockett and Eddings and the case law that we've laid before it.
Jodi just has a glow to her. People were very drawn to Jodi, not only because she was beautiful, I mean, because she's a great girl.
The issue here is why Ms. Womack is not here to testify. As the court has been informed, on May 15th of 2013, I conducted an interview with Ms. Womack. On 2 separate occasions, she failed to answer my questions. Specifically, the first occasion occurred when I started to talk about her drug use as it involved the witness and the defendant. At that point, she deferred and chose not to answer. Rather than end the interview at that time, I chose to continue and seek whatever it was that she had to say. At one point, when she was asked about photographs of herself and the defendant, she started to equivocate. And at that point, she asked or indicated that she wanted to leave the room. There are many issues that are involved with this witness, and not the least of which is that she faces some prosecution, for lack of a better term, involving those photographs. We don't need to get into the detail of it because it is clear that she didn't report that income, and that would subject her to criminal penalties. Additionally, the use of illicit drugs, again, may or may not subject her to criminal penalties depending on her status in California. It is clear that she has some sort of substance abuse problem, and that's something that would have been addressed at trial while she testified. The facts indicate that this individual, if she were to call to testify on advice of counsel, would not have testified. She did, in fact, fail to respond to the first question involving drug use, and then she invoked her Fifth Amendment rights, making this issue of whether or not there were any threats viable. It's an issue that can't be reached if she's not going to testify to start with anyway. We really don't know the reason why she failed to show up and why she fails to want to testify. Additionally, my information, which I would have asked of her on the witness stand, would have been as to whether or not she believed or was in favor of testifying in this particular case, because she believed that the defendant had a bad background, or so to speak, and that she did not believe that there was anything in her background that would have called for leniency.
You know, he wants to disparage her for drug use, that sort of thing. And that's exactly what we're talking about here when I brought up Smith and when I brought up Zawada. When you have a prosecutor, when this court allows a prosecutor to personally attack witnesses and counsel, that breeds an environment where this sort of thing is endorsed. And that's exactly what has happened throughout this trial with the intimidation. She is afforded certain rights at the sentencing phase. The right to present a full and complete mitigation case. That right has been ripped away from her, Thus, a mistrial, again, as I said before, is the only lawful remedy at this point.
All right, the court finds the defense has failed to establish that the sentencing phase cannot go forward and that the defendant cannot receive a fair trial in that sentencing phase. This court can only speculate as to why Ms. Womack is not here today. Without more information, this court finds there is no basis to grant a mistrial, and so the motion for mistrial is denied. Mr. Nurmi.
Ms. Wilmot and I would move to withdraw from the case yet again. Under Strickland v. Washington, we are in a position where we cannot provide effective assistance to counsel at this phase of the proceedings. We cannot present the complete picture that is incumbent upon us. Rule 6.8, as well, Arizona Rules of Criminal Procedure, imposes that duty upon us as well. We cannot fulfill that duty because we cannot provide the picture. There is no speculation as to why Ms. Womack is be here. She feels threatened, she feels intimidated, and she doesn't feel like she can be here. So that being said, under Strickland, Ms. Wilmot and I cannot meet that standard and then move to withdraw.
Your motion to withdraw is denied. All right. Are we ready to proceed with the jury?
Your Honor, we will not be calling witnesses in the phase given the court's ruling and the incomplete picture. We will not be calling witnesses in the defense case.
All right. All right, is there anything else?
Yes, Judge, the other thing we'd be asking for, consistent with this court's ruling on both aspects of the motion for mistrial, the sentencing phase, we'd be asking a stay of these proceedings so we could seek special action relief.
The motion for stay is denied. All right. Is there anything else for today?